Welcome to Huddleston Bolin. Today we'll be featuring Scott Sheets, a partner in the firm's Huntington, West Virginia office. Scott's practice is focused on employment law and labor management relations. The focus of today's presentation is dress codes.
Many employers have a certain image that they want to project, not only to the workforce, but also to the public. What happens when you get that employee or applicant who doesn't quite jive with what you want? What happens when someone comes in for a job interview and he or she has tattoos, piercings, a religious headscarf? Can you turn them away? Do you have to hire them? The answer is not necessarily clear, but there are certain guidelines to think about. Let's talk about several of the different categories. Hairstyles. Something that you might encounter for an applicant or even an employee are dreadlocks. Dreadlocks, while innocuous, might be something that an employer doesn't want to necessarily present to the employment workforce. However, you need to be careful because the EEOC has taken a position that dreadlocks might be protected, and that if you discriminate against someone because they have dreadlocks or because they have a beehive hairdo or some other type of hairdo that is different, you might be committing racial discrimination. You might be committing religious discrimination if the hair is worn a certain way as a religious tenet. In other words, you need to be careful when you make any type of judgment regarding people's appearance. What about weight? Weight is often a form of silent discrimination. Employers take a look at an individual who's applied for a job and they make certain assumptions about someone because of his or her weight. They think they can't do the job and they therefore don't hire them. That's a form of disability discrimination. The EEOC has taken the position that obesity itself can be a disability. And the amendments to the Americans with Disabilities Act tell employers that you're no longer to analyze in depth whether or not an employee has, or a potential employee has, a form of disability, but more or less assume the condition might be a disability and look to see whether you can reasonably accommodate it. With weight, what you need to be doing with employees or job applicants is to provide him or her with a listing of the job's physical requirements. How much weight can be lifted, how much walking is required, how much standing is required, and then ask the employee or the applicant, is this something that you can do? Is this something you can reasonably do with or without an accommodation? Apply that across the board to all your employees, not just those who you believe are overweight. What about religious adornments? The employee comes in and he or she has a hijab, or they have a crucifix or a cross. Can you tell the employee you don't want to see those? Religious discrimination requires the employer to be aware that they have a duty to reasonably accommodate certain religious tenets. And if the employee legitimately has a reason why he or she wears a scarf or why they wear a particular adornment, and there's no real burden upon the employer to accommodate that, then you have a duty to accommodate that. What about tattoos and piercings? We've all seen those out and about, and employers are encountering them more in the workplace. The job applicant comes in and has multiple piercings on his or her face. They have tattoos that are openly visible and somewhat extravagant. Can you tell the employee or the applicant, in order to have the job, they have to keep those covered? Basically, the answer is yes, you can do that. Unless there's a particular religious reason for a tattoo, there's no reason you can't explain to the employee that he or she needs to keep those covered at all times during the work hours. Now, what you can't do is tell the employee you cannot have a tattoo, you cannot have a piercing. You can tell them they can't be displayed during work hours. Now, with regard to piercings, if you're going to limit it to just earrings, be aware that if you're applying that only to women, and allowing them to wear earrings but not men, you may be even committing sex discrimination. Finally, having talked about hair and weight and adornments, we need to also talk about actual dress. Many times employers are confronted with employees who are wearing clothing that is inappropriate for the workplace. It can be in terms of low-cut tops, mini skirts. What's the employer to do? If you have an appearance code or a dress code, you should be general in terms of what you expect employees to wear so that will give you leeway to enforce it. Don't say skirts can only be a certain amount of inches above the knee. or tops can only be a certain lowered length. In other words, have your employee dress code state that the employees present a general business appearance, if that's the type of business you have, and enforce that uniformly across the board. Don't allow certain employees to get by with certain forms of tops and other employees to get by with certain forms of skirts. Enforce it uniformly so that there's no question but what is expected of the employees.
Thank you for joining us for this informative video. Please don't hesitate to contact us at Huddleston Boland for more information or to discuss your legal needs.